This is Horum with Horum's Quorum. My guest today is Judge Matthew Kennelly of the Northern District of Illinois. I'm fascinated by federal judges because they're maybe the last true generalists, and I think there's a lot any of us can learn from how they make high-stakes decisions on a wide range of issues. It's rare to get an opportunity to sit with a federal judge, particularly one with as busy a docket as Judge Kennelly, so I hope you'll value these 2 hours as much as I do. Judge Kennelly, it's great to see you again. Thanks for taking the time to talk.
Happy to be here.
So we talked last time about a few things around your docket and some of the interesting implications from all the kinds of matters that you manage. I thought we'd begin by talking about your intake of cases. I think you said you're getting these days about 30 new cases a month. And tell us about that flow. So you get these cases in, and then how is it that you are processing these cases and moving them along? And help us get a glimpse about that part of your role.
Sure. So to start off with, federal district judges are basically what I would call the last of the generalists. We get all types of cases, both civil and criminal, of varying degrees of complexity. As you said, I get about 30 new civil cases per month, give or take a little bit, couple or three new criminal cases per month. So I'm right about in the average in our court. I have at any given time about 280 civil cases and about 40 or 45 criminal cases at the moment. So what that means is that if I essentially do nothing in a month, my caseload goes up by 35. If I do a lot in a month, it might go down a little bit, but I still get those 35 new cases in. And I sometimes, in talking to interns and law clerks, analogize the job to that old I Love Lucy episode with Lucy and Ethel working on the candy line, the candy assembly line with the candies coming down, and the candies keep coming down at a constant rate, and they're spending a lot of time on decorating them, and eventually they get behind very quickly, and the candies start falling off the line, and they're putting them in their hats and their pockets. So that line is my new cases on a given month or day or week, and I have to keep the line moving. And so when a case comes in, particularly on the civil side, I have to get a handle on it and basically at a fairly early stage get it organized and get the case moving so that it doesn't languish. Most lawyers are overly burdened. They have too much to do and not enough time to do it in. They're always juggling. And so I need to make sure that, any given case that's assigned to me stays at least on their radar screen somewhere and doesn't, because if I don't do that, it'll fall off the radar screen and it'll just sit. And in the long run, that's not good for the legal system because it's not good for cases to languish. They should get decided in one way or ruled on, settled, or resolved in one way or another.
I think part of understanding that process, I think it's important to understand all the parts involved, your brain work. So when you say that you're getting a handle on these simple cases, you're getting a sense of what some of the early work that needs to be done on these, how much of that is based on substantive determinations of the subject matter? Say, okay, well, if this is going to be a class action, that means this, or this is a personal injury, that means that. Then, I'm trying to get a sense of like how much of that is determinations you've made based on your experience and understanding the subject matter.
Yeah, so case management is really that just proves that I didn't turn off that stupid phone. Okay, so I'm just going to decline it. Sorry about that. I'll answer that question. Do you want me to just pretend like it just started answering?
No, or you can just go with this.
Okay, so yeah, I lost my train of thought. Okay, so basically what happens is a case management is, there's no form book that says this is what you do. There's a set of rules called the Rules of Civil Procedure that set these sort of very general outlines that basically say, get the case organized. And that's essentially what they say. And so it's up to a judge like me to decide how that happens. And I do that largely based on my experience both in practicing law, for 18 years before I became a judge, and in working as a judge for 20 plus years, to get a sense of how quickly, slowly, medium speed, whatever a case should progress, and how complicated it's going to get at what stage. Now, some of that is going to be dependent upon things generated by the parties. So for example, a lawsuit may come in and the parties may come in and say, we're already talking about settling the case, and I can just kind of send it off one way. Or a lawsuit may come in and the defendant, the party who's been sued, may file some sort of a complicated motion saying the case lacks merit, you should throw it out right now. They may deal with it in another way. The majority of cases fall somewhere in between those two, and I basically have to decide based on my experience and obviously with a lot of input from the parties, how to organize things and keep them moving. The judge is, of all the people who are involved in the case, so the lawyers, the litigants, and the judge is the most ignorant, knows the least about the case. I know about case management, and I can kind of figure out what particular pigeonhole or category or stovepipe to put a particular case in, but I'm not going to know exactly how complicated or uncomplicated it is until I spend time talking to the parties about it and hearing from them about how complicated it is. So what I typically do, and I do this not because I'm a nice guy, but because I think it's the most efficient way to do it, given what I just said, is I'll ask the parties to propose a schedule to me. How long do they think what do they think they have to do, and how long do they think it's going to take to do it? And I sort of measure that against a rough yardstick of my experience and determine whether I think it's reasonable or not. Overwhelming majority of cases I do, and then I direct them to follow the schedule that they've already agreed to at the outset.
And so if counsel, if you say that the judges are going to be least knowledgeable about the case, I think correspondingly, I think the corollary of that is that the attorneys are the least have the least information or understanding about how the judge thinks about case management. So I think that's a pretty interesting to follow up on. And so I think maybe one way of approaching that is, what case management technique have you developed over time that you're most proud of or you found the most effective?
Well, yeah, I'm not, I don't think I have a trophy case that has my best case management techniques. That would be kind of a boring trophy case. But what I would say is listening is a pretty important thing. I mean, I litigated both civil and criminal cases for quite a number of years before I became a judge, and I appeared in front of judges who had every case be handled the same way. You come in, your trial date's in 180 days, or your trial date's in a year, or I'm not going to give you a trial date. Just go off and do whatever you want to do. And without really any care or even interest in what the parties had to say. And that's certainly a way of doing it. Basically what that's called is elbowing your way to the front of the line. Mm-hmm. It's basically like saying to the lawyer, I don't care about the rest of your cases, the rest of your life. My case goes at the top of the list. You're just going to deal with my case. And, that's a way of doing it. And I guess for those judges, and I appeared in front of judges like that over the years, that works. And I'm not going to say that there aren't points in a case where I tell people, look, I know you're asking for more time, but I'm not going to give it to you. But I think as a general technique, that's kind of the opposite of how it ought to work, because we have to, under the rules, make sure things get decided not just in a speedy way, but in a just way. And if basically your technique is to tell everybody you got to floor it from day one, that's not likely to result in a just resolution. It'll result in a resolution for sure, and it definitely worked for those judges that I appeared in front of. All those cases would go away before the 90-day trial date. But were they going away in a way that they should have gone away? Probably not. So what I do is, like I say, I try to listen. I try to impose some sort of, reasonableness boundaries on what I listen to. In other words, if somebody comes in on a routine, a breach of contract case and says it's going to take us 6 years to conduct discovery, unless they tell me that the witnesses are all in, Dubai and Taiwan and Germany and, the Philippines and various other places, I'm going to say, no, folks, I'm sorry, that's just not going to work. Mm-hmm. If they do something that's within a range of reasonableness, which is a range, I'm probably going to go along with it. And then in terms of techniques, one of the things that I do think it's important to do, and the Chief Justice, or current Chief Justice, has kind of emphasized what the rules of civil procedure have kind of always said, at least in my career, that the judge should be an active manager, that it's important for judge to be aware of and actively manage their cases, I ask questions. If somebody wants more than the average amount of time, I ask them why. I don't just routinely agree to it. I get them to justify it. I try to bring up the topic of voluntary resolution, settlement, mediation at regular intervals. One of the reasons for that is that I observed in the course of practicing that many lawyers believe that if you're the first person to bring up settlement, it's a sign of weakness.
Mm-hmm.
And I happen to think that's false and probably demonstrably false, but people believe it, so you got to deal with it. And before I started in this job, I spent a lot of time talking to other judges in our district, and I had been in front of most of those judges and observed their techniques. And I still remember one of them saying that you one of the ways you take the issue of reluctance to discuss settlement off the table is you just tell people you're going to make a settlement proposal by X, you respond to it by Y, and then people can go back to their clients, and the client isn't saying, wait a second, this is a sign of weakness. No, they can say, no, the judge has ordered us to do this, and so now we're going to do it. So I try to do that. I think that's reasonably effective. I didn't invent that. That comes from a magistrate judge named Mort Denlow. That's at least who I got it from. Now retired and doing private judging, but other things. The other things I try to do, if there's without getting too far into the weeds of civil procedure, it's pretty common, for example, in civil litigation for the defendant to file a motion saying that the complaint is deficient on its face. It's what we call in federal court a 12b6 motion. Back in the mid-aughts, the Supreme Court case said in a case called Bell Atlantic versus Twombly that district judges ought to be able to just figure that out. It's pretty easy, right? Now, I will say that none of the judges on the Supreme Court who said that had ever been a district judge, I think, at that point in time, but that's not altogether wrong. And I think it's a certain level it's true. And so what I try to do on those types of motions is, instead of saying, okay, everything's going to grind to a halt and we're going to brief that motion for 2 months and then I'm going to sit on it for a while and decide it, I'll look at the motion, I'll look at the complaint when they first come in, and I'll say to the plaintiff, if I think the complaint's weak, I'll say, look, you got some problems here. You might want to go back, and if you can, ethically do it, you might want to think about amending your complaint. If I think that the motion asking to throw out the complaint, dismiss the complaint, is meritless, I don't make people respond to it. So I don't routinely set briefing schedules on those kinds of things. One of the other things I do, again, and I didn't learn this myself, I adopted it from other judges around here, but I certainly observed it in practice, is that, it's a pretty common thing in civil litigation for there to be disputes about discovery, who can get what from whom and when, and how broad it can be and how narrow and so on. And I appeared in front of judges over the years in this district and other districts who, when there was a discovery dispute, they'd set a briefing schedule, like just as a matter of routine. And so you'd brief the motion for the discovery motion for a month, and the judge would rule on it a couple weeks later. And guess what would happen during those 6 weeks in the rest of the case? Nothing. Everything stops because everybody's waiting for the judge to decide. Why does that need to happen that way? So when I did my rounds before after I got confirmed and before I started the job, one of the sort of recurring themes I would hear from judges who did their own discovery supervision is, don't let people brief discovery motions. Unless they're really complicated, do your best when they come in, rule on it right then. Hear argument and rule on it. And so I've done that. I mean, it's very rare for me. There's a pandemic exception to this, like everything. But very rare for me to set a briefing schedule on a discovery dispute. Typically what will happen, so nowadays, in the old days, people were regularly coming into court, and so they'd have to say, here's my discovery dispute, I'm going to come in front of the judge in 3 days, and I'd get it resolved when they came in. Now it doesn't happen that way, and so what I typically do is I say, okay, you filed your discovery request or motion on such and such a day. We're going to have a phone conference a week from today, and I'm going to decide it then. If you want to file something before that, go ahead and file it. Otherwise, just be prepared to talk about it on the phone. I rule on it then, and then we've lost 4 or 5 days in a case, not 6 weeks. I mean, I was in cases where, what would happen is that the judge would set a schedule on discovery motion. I and the other litigants would bring everything to a halt, and then the thing would get lost in the shuffle, and 4 months later, you're still waiting for a decision, and in the meantime, nothing's happened in the case. In any given lawsuit, delay can be in somebody's interest, but just in terms of the overall system, it's not, and it shouldn't be that way.
Yeah, I think another thing about that is my understanding is that all things considered, delay means more money to the lawyers.
Oh,
And
there's no question.
yeah, I mean,
At least when both sides are paying as they go. That's definitely true. It benefits the lawyers. And as the judge that I clerk for used to say, there's maybe no higher and better use to which a person can put their money than the payment of a reasonable attorney's fee. And so with a half smile on my face, I sort of agree with that. But that doesn't mean I have to bump the tab up.
So I wonder if, in talking about these different styles to approaching how to handle discovery disputes, I'm kind of interested in the style aspect of that. Do you feel like there are trends in jurisprudence where, maybe there's a trend? Is there a trend, for instance, like if you say, in the Northern District, there is this more underscoring of the active management approach to to the judge's docket. Do you feel like those are things that come and go, in, say, several
No,
decades?
I would say over time, the trend has been one direction, and that is with more active management. Now, that's not a straight graph going up. There's some bumpy lines on it, and different judges, that trend line is moving at different rates. In our we have a very large district, 21 active district judges, 8, 9, 10 senior judges at various levels of activity, a dozen plus magistrate judges, all of whom are supervising cases. So anytime you got 40 people, 40 more or less life tenured people doing something, you're going to have at least 40 different ways of doing it. But my sense is that of the judges who do manage their own cases, and I, of course, have the option to defer that to a magistrate judge, but of the judges who do manage their own cases, I think the trend is, over the course of the 40 years I've been a lawyer and a judge, has been more management, not less.
To what do you attribute that trend?
So it's a function of the rules of civil procedure that when I started, I'm holding my fingers up, being about an inch thick, and now they're about 2.5 inches thick. So more rules means more stuff to talk about. But it's really just I think just a general trend in federal litigation promoted by currently the Chief Justice, and it completely correctly, I think, and by the judicial education we get, what we referred to in the federal system as baby judges school. That's the way you're trained, and as lawyers come through the system, of course, most but not all people who become federal judges have been federal litigators, and that's what they're used to, and you tend to kind of do what you've seen. And so I think it just increases over time. And then what people, many, not all, probably most, but not all judges tend to realize is that it's more work for you, but it pays off. The payoff is the following. So again, I could just do nothing on my cases, just wait for the motions to come in and rule on them, just let nature take its course. And there are judges who operate that way, and they have nice, they have nice lives, just like I have a nice life. Okay, it's a way of doing things. But here's the difference: I have 280 cases. That judge has 450, and any given 10 cases is going to generate a certain number of things that I'm going to have to spend a lot of time on, like what we call a summary judgment motion, or a motion to dismiss, or class certification, or maybe a trial, or something like that. And if I have 450 cases, if 2 out of every 10 cases generates a motion for summary judgment, that's going to be a much bigger number than if I have 100, than if I have 250. So the payoff in the management is you're putting more into the front end, but you're having less work on the back end, and less, the cases get resolved if they're paid attention to on their own. 97% of civil cases, if not more, are going to settle at some point. What you can do as a judge, perhaps, is kind of move the needle in terms of what point they get settled at. Is it sooner or is it later? Is it 5 years after the case gets filed, or is it 2.5 years after the case gets filed, or 1 year after the case gets filed? And the more actively you manage it, the more likely it is that number is going to get shortened. And I think, again, in a given case, that might be detrimental to one side or another, but from an overall system standpoint, it's good for the system.
Do you have any intuitions about the satisfaction parties have with settlement at those different phases. So how much more satisfied are parties with
Yeah.
early resolution?
That's a great question, and I don't know that I've never seen a study on it. It probably could be studied. I will tell you that my sense is that when cases get settled, people tend to be satisfied with it. Doesn't mean happy, means satisfied. In other words, it's a cost benefit thing. It's a better resolution than what would happen if you didn't make the resolution. And so my guess is that the satisfaction level probably doesn't vary a whole lot. And I mean, if you look at it from a sort of a holistic standpoint, if I'm a let's say a defendant who's paying hourly fees, and I settle the case after paying my lawyer $50,000 as opposed to after paying my lawyer $250,000, I ought to be happier. At least if the settlement's the same. Of course, you'll never know, but that ought to be beneficial to me. And the same is true on the other side, at least if the plaintiff is paying an hourly fee. If it's a contingent fee, it's a different story.
Mm-hmm. To pick up, I think in a couple different ways, you alluded to the different styles that different judges have, and you're all equals in that way. You all can just trade ideas, but you're all left to manage your own chambers, in your own way. And you tied it to the fact of lifetime tenure, because then just over the course of someone's multi-decade career, they can continue to go in some direction and really refine some process, and that could be maybe significantly different than another judge. So to me, that's an interesting consequence of lifetime tenure that I hadn't considered before. What are some of the other consequences of lifetime tenure? Because that's a very specific, we don't really have that in a lot of other aspects of society. So it's a very unique thing. And by virtue of you being a generalist, you see so much about how else things are done. So what are some of the non-obvious implications or consequences of lifetime tenure?
Well, okay, it's easier to start with the obvious ones. The obvious one is that since I don't have to run for retention or election or whatever, I don't have to be concerned that if I issue a decision that a columnist for the Tribune thinks is an outrage, that I'm going to lose my job. And who knows whether I'd do that anyway, but the fact that you don't have, it doesn't even cross your radar screen, I think is a significant thing in terms of, how judges operate, that you're not constantly having to think about looking over your shoulder and trying to figure out what might be gaining on you. So that's the big thing. I mean, the other thing is that, I mean, this is suggested by your question, it gives you an opportunity to try out different things. I don't have to do the same thing now that I did 10 years ago. Now, so the obvious follow-up is going to be, okay, what are you doing differently? So I'm leading with my chin on this one. It all ends up being nuance, and one of the sort of the countervailing factor for this thing that gives you kind of the liberty to do different things and try out something and see if it works and so on. The countervailing factor is, I don't know, you could call it the cocoon factor, or what some people call robe-itis or whatever. And that is that, you're in this little tiny world. You don't get any honest feedback from anybody. It's always, uproarious laughter when you say something that's even mildly funny. It's always, oh, you're such a wonderful pillar of the community, and by the grace of God you get put on the bench or whatever. And there's sort of this temptation, if you're not into kind of a self-examination mode, to kind of figure, hey, everything's great, nobody complains, everything must be going fine. And one of the, for me at least, one of the things that you constantly kind of have to elbow yourself on, I think, is what am I doing that could be done differently and that might successfully be done differently? And the problem, of course, is that we're in this system here. We're in our own little world. It's like I said, there's 40 judges. It's like 40 different little law firms. We're all in the same building, But it's not like, when I was with my old law firm, which was 6 lawyers, and I just, show up in the next person's office and say, hey, what's going on? I mean, that doesn't happen around here all that much. But, we do have opportunities to get together, and you hear how other people are doing things differently. And I mean, so recently, for example, I've always, or at least more or less always, managed civil cases in kind of the active way that I described. I had not done that in criminal cases. Criminal cases are different in a lot of ways, but the lawyers tend to be more on the ball in terms of keeping things moving, and you tend not to have to manage them as much, or at least that was my theory. And recently, this probably goes back to a little bit before the pandemic, I was on a committee because we were trying to deal with some issues having to do with staffing of the Marshals Service, which is constantly understaffed, and how we could deal with that. And one of the things that came out of that is that our court was having a lot more in-person appearances on sort of routine status hearings in criminal cases than virtually every place else in the country. And I think that's probably just sort of a carryover for what we do in civil cases, because that's what we had always done in civil cases. But when you've got defendants in custody in criminal cases, anytime one person comes to court, there have to be 2 marshals with them, plus the people in the lockup and so on. So we had these big staffing problems. And one of the things that a judge who's, happens to be on my floor, but has been a judge, maybe 12, 15 years less than me, was doing is he was doing the same kind of thing in his criminal cases that all of us had been doing in our civil cases, which is getting kind of frequent and detailed reports from the lawyers about, what discovery have been produced, when's it due, when are you going to get it to them, and just constantly nudging them, not making the parties come in for that, but making them file kind of reports. And if somebody says, well, Judge, the prosecutor says, well, we're going to get the defendant a draft of a plea agreement in the near future, you'd say, fine, you got 2 weeks to do that. Whereas most of us, myself included, really weren't doing that. And so I think I'm going to try that out. And so I kind of changed how I was dealing with criminal cases kind of as a result of that. And does it have an effect? Yeah, everything affects things in some marginal way, but I think it does. And it keeps people a little bit more on the ball. They don't get the sense that all I got to do is kind of show up and say, oh, we need more time, and the judge is just going to send me away. And so, bringing it back to your question, which I've gotten pretty far away from here, you do have the opportunity, if you keep your ears open and you talk and you listen to see how other people are doing things, and maybe say, hey, I'm not going to completely change my procedure. I'm going to try that out and see how it works. And if it works, then you can maybe change how you're doing things on a regular basis.
So it sounds like there are some ideas like this one that just it's unlikely someone's going to say that isn't better. It just seems so likely to result in better case management. And so it seems like there's at least some no-brainers. And so, what are the obstacles you see to more widespread adoption of that? Because it sounds like, I feel like in the conversation we've had recently, I think case management has been a key thing that you've underscored about your role. Maybe it's because it's the least appreciated part of your role, but it also seems like it's very much top of mind and very just day-to-day blocking and tackling. And so I'm just kind of curious about the ways in which you'd like to make that process easier for yourself and other judges. And, I think there's also maybe a benefit to the public and maybe a more consistent application and a consistent administration of justice. So what are your thoughts on that needing to be implemented,
right.
some kind of best processes?
The last thing that you said, consistency, I think is a big and probably unsolvable issue on a large scale. There are smaller districts, smaller federal district courts, let's say the 2 or 3 or 4 judge districts, where what they have done is they've basically developed kind of templates. Your case is a category 1 case, or it's a category 2 or category 3 and category 4. And depending upon what category it is, you're going to have this much amount of time to do X. You're going to have this much amount of time to do Y. You're going to have this much amount of time to do Z. And yeah, all those dates are subject to modification by the judge, but the notion is your case is categorized, it's going to go into a pile. And So in those districts, everything's very consistent. Just like when we had mandatory sentencing guidelines. Now, this is not a great analogy. There's a big difference between how somebody manages a civil case and how many years they have to go to prison. Okay, obviously, but back when we had mandatory sentencing guidelines, at a certain level, sentencing became easy. You count up the points, you get a range. You sentence at the bottom of the range, the top of the range, or the middle. It's not a big range. You're done. It's very easy. All you have to do is calculate the points correctly. And so there's consistency. And in the law and in the system of justice, there's this constant tension between consistency and individual attention, and treating people as individuals and treating cases as individuals. And over time, that pendulum tends to go back and forth. So, and I'm going to keep up with the sentencing analogy here for a moment. So, the Congress passed in the mid '80s something called the Sentencing Reform Act, which is the thing that instituted what we call the federal sentencing guidelines. And the two primary sponsors of that legislation were Ted Kennedy and Strom Thurmond. And they both, and what it did, so before that, sentencing was completely discretionary. You might look at the same case, let's say an income tax evasion case, and Judge A might give the same defendant probation, and Judge B might give him 10 years in prison, or whatever the maximum is for income tax evasion. And no review. It was all considered discretionary unless the judge had considered some inappropriate factor. That the sentence is what it is. So Senator Thurmond, I think, and I may be getting history a little bit off here, but Senator Thurmond was more interested in the consistency part of it. Why is Judge X giving somebody 10 years and Judge Y giving somebody probation? And Senator Kennedy was perhaps more interested in that, but also more interested in some of the kind of outliers on the high end. So each one was kind of interested in the outliers on the other end, and the result of it was the sentencing guidelines, which for 20 years were, close to 20 years were considered mandatory. You couldn't vary from whatever that little range was, except in very unusual circumstances. And so we had this system which was, you're going to get the same sentence in the Western District of Oklahoma as you are going to get in the District of Rhode Island, in front of two different judges for the same crime. On the other hand, nobody was going to consider whether, you maybe had sick parents at home that you were taking care of, or that you were the sole support for your 4 children, or you had some sort of previously undiscovered mental disorder that was causing you to commit the crimes. None of that was going to be considered. Or whether, on the other hand, you were somebody who, was just kind of a bad dude, and anytime you got out of prison was going to do something to get back in. And so we adopted consistency, and we sacrificed individual attention. That changed in the mid-2000s. The Supreme Court decided that the sentencing guidelines were advisory and not mandatory, and so now you have to consider them as kind of a goalpost, guidepost, starting point, not an ending point. And of course now we as a result of that, over the last 15 years, we're now back to quite a bit of variation among judges within districts and among districts in terms of how similar cases get sentenced. And there's probably less concern about that nowadays, but every now and then you see somebody say, hey, is there something wrong with this? I mean, why does somebody get, probation for this drug crime in the Eastern District of New York, and in, the District of Kansas, they get 20 years for pretty much the same crime? Doesn't make any sense. And I get that. And so so the pendulum kind of tends to swing back and forth on these things. And I guess to try to bring this back home, I mean, we could have a system here in our district where you would know coming in that your case gets filed here, your summary judgment motion, your motion asking the judge to throw out the case or whatever is going to be due in 18 months, period. And that would be completely predictable and completely consistent, and it would also be massively stupid. Because it wouldn't take account of the differences that might make one case or another different from that. So in the law, we have this constant tension. Now, I will say that our court, to a certain extent, gets criticized for the variation in the way different judges handle cases. I just chalk that up to humanity. We used to have in the old days, personal injury lawyers, for example, and both sides would say, "Hey, wait a second, why should I be in federal court? If I'm in state court, I know my case is going to get above the line," as they used to call it in the Circuit Court of Cook County, 3 years and 6 months after the case gets filed. In federal court, if I get assigned to Judge so-and-so, I'm going to get a trial date in 9 months. If I get assigned to Judge so-and-so, who knows if I'm going to get a trial date before he retires. And that those are problems, but it's kind of inherent. Anytime you try to smooth out the variations in the graph, you're going to leave some significant number of cases being treated in a way that people will consider unfair. And anytime you give more or less complete discretion to the person who's handling them, you're going to get the criticism, completely legitimate, that there's no predictability. And so what do I try to do? I mean, on my own, I can't deal with everybody else's universe. I try to deal with my own universe. I try to treat similar cases in a similar way as best I can, understanding that there's no two things that are exactly alike. I do worry, particularly I keep going back to sentencing, but it's the most serious thing we do around here. I do worry about those things. I sentence a person in one case to such and such a sentence, and then a case comes along 6 months later that seems kind of the same, and I think, man, I should impose a greater sentence here, but wait a second, 6 months ago I gave this other sentence. Can I really justify that to myself? And nobody on the Court of Appeals is going to come back and say, "Hey, Kennelly, you sentenced so-and-so 6 months ago to a lower sentence, explain the differences here." That doesn't work that way, but I think about it, and I think judges do think about those kinds of things, and hopefully try to maintain some sort of internal consistency, at least on their own over time.
That's interesting. I don't think enough about the criminal docket. I don't know enough about it. So, because, my litigation has always been civil. And so something that I think is maybe desirable in a civil context, but less desirable in a criminal context, is some aspect of unpredictability, I think that's part of, I've always kind of felt that tacit to two-partisan litigation is saying, we understand there is a riskiness to this, and we are hoping both of us facing this risk will drive us to resolution and settlement. Right. And so it's kind of curious to think about the ways in which, in some ways, that unpredictability is a feature, not a bug.
Oh, it's a feature for sure. It's a feature, and it's a feature in everything. As a lawyer, I handled both civil and criminal cases, and the calculus is different, and the consequences are different in the two types of cases, but the same uncertainty plays out in both. In the civil case, you could get a quote unquote runaway jury, or you might get a judge who just has a complete antipathy to a particular type of case, and how's that going to affect things? In a criminal case, you don't know. If you go to trial, is the judge going to think that this is a way worse case than you think it is now? Is it going to be treated differently if you make a deal, and so on and so forth? Yeah, that's a feature. It may also be a bug, but it's a feature.
Well, going back to what you're saying, I think part of the active management that we're talking about and the benefits of consistency, and the desire to be able to listen to parties and take in circumstances. I think a key part of that, and something that you've referenced a couple of times now, is listening. And I think I have a naive intuition about what listening is, but I imagine over time you've developed better techniques for listening and facilitating communication with your forthright communication. So what are some of those techniques that you can develop?
Part of it is filter. There's a lot of similarity between, particularly on the civil side, between case management and parenting. Okay, so, and it's a combination of carrots and sticks, and you have to listen, but not necessarily be swayed by somebody whining about this or that. And there's every bit as much whining by lawyers in civil cases as there is by 4 and 5 year olds. Not that I'm comparing the two necessarily, but yes, it does. At some level, you kind of think about it that way. I can't say that I have a template that I kind of try to fit everything into, but um, I guess what I try to convey to people is, look, if you pursue your case and what you have to do on your side in a diligent way, then you're way more likely to get leeway from me when you need more time or have a problem or need an exception or something like that. If, on the other hand, what you do is basically just ignore everything until a week or 2 weeks before the deadline is about to run, and then you engage in this flurry of activity, and then you come in and say, oh, Judge, we just found out something. And it turns out that the reason you just found it out, even though you've had 10 months to find it out, is you didn't do anything until 3 weeks ago. I'm probably going to have a little bit less leeway with you. And that might sound, oh, geez, that's not really fair. But I try to convey that to people kind of from the get-go, that don't wait until the last minute. I mean, that goes back to the thing I said about lawyers juggling. Every lawyer's got many, many, many deadlines that he or she has to deal with. And you're always constantly juggling. And what I think as a judge I want to convey to people is that I get that. I get that you're going to have to juggle. I get that you're not going to be able to necessarily comply with deadlines, but I want you to treat the case as something that's significant and not something that just sits on the back burner until there's, until until you start getting the warnings from Outlook saying you've got, meeting day after tomorrow or something.
So I think part of what you're talking about is, I think it also ties into, when you're saying in the context of the lifetime tenure and some of the ways in which that insulates you, of course, from, a lot of scrutiny or pressures of certain kinds. But then there's a concern about rovitis. And so listening seems to be a key part of that as well. So what are the things that help you understand the considerations that law firms go through or clients go through? Like, what are the ways that you are staying grounded in getting good understanding of what's actually going on behind the scenes here?
Okay, so part of it is, and I mean, I've been a judge for going on 22 years now, but it doesn't seem like that long, and I did have a pretty very active both civil and criminal practice. And so part of what I'm doing is trying to make sure that I don't lose touch with that and the understanding of the pressures and the multiple pressures that I was under at the time when I was a practicing lawyer, and that I take account of that when I'm managing a case. So that's certainly part of it. Part of it comes from, I mean, you can kind of sit around here in an ivory tower or the equivalent, particularly now since there's nobody around, and just kind of, go about your business and not pay any attention to anything. I try to stay involved in, groups of lawyers, bar groups, or what we call inns of court, things like that, where you're talking to lawyers regularly. And again, they're not necessarily going to come up to you and say, hey, Judge, the way you managed that case really stunk. That's not going to happen, but you do learn things by staying up on, what's going on in practice about what happened. So one big example for me is that, I became a judge in 1999, and electronic discovery, as we all know it now, pretty much didn't exist at that point. The digital revolution was just kind of starting to happen. It really hadn't affected litigation all that much, and I had no idea. I mean, I never had to deal with, drafting search terms and protocols for ESI and things like that. And so, what I've tried to do is, thankfully, we have opportunities for continuing judicial education, and not just that, but being on panels with lawyers. And when you get asked by the local bar association to be on a panel about electronic discovery, I mean, for me, it's important not to just sit up there and pontificate, but to kind of listen to what people are saying, because you learn a lot from that. And so I think that's part of it. Part of it comes and less about the practice ends, but about what's kind of happening in the world. It comes from the fact if you have, we're all allowed to hire law clerks, basically lawyers who assist us, and And if you have what we call term law clerks, in other words, there's new people coming in every year, every couple of years, that helps you kind of stay grounded in what's going on. And then a lot of it you just learn from cases. I mean, I've a lot of what I know about electronic discovery, I know from kind of learning it the hard way and having disputes presented to me and having to figure out what they're all about and listening to the lawyers and how does this work and how does that work and so on.
So one thing that you mentioned is, you've mentioned in a couple different ways is getting honest feedback. Of course, lawyers are all just going to laugh at your jokes and, not exactly walk up to you and defend.
By the way, I am actually quite funny. So, so not all the laugh is fake.
You did have, I have to say, there was one Linen dinner where you made remarks and it was very funny. It was objectively funny. So I have to give you that.
So like 1 out of 100 times I was actually funny. Okay, yay.
Well, I still remember the joke, and I don't remember. I mean, how many other lawyers have given a talk, and I remember the joke. So I think that
okay, that's good.
Well, so let's talk about that because I'm interested to know what kind of feedback do you wish you had? I mean,
Yeah, so that's a really tough question. I mean, because it's going to be really hard to get anything good, So every now and then, this or that publication does evaluations of judges. So what does that end up being? And it kind of depends on how they go about doing it. So we've had an organization here locally that at various points in time has reviewed judges both on the state and federal level. Not all that often because it's a massive undertaking. If you're going to do it, so I mean, obviously you can, there's, I suppose, somewhere, although I don't go looking for it, the judicial equivalent of Yelp reviews, probably, judgesajerk.com or something like that, where people can kind of post all their gripes. But that's largely going to be all the negative information, and who knows how much of it is tainted by the fact that the person lost a case and they're just ticked off about that. So what you ideally would get would be some, sort of more broader sampling of done in a fairly systematic way that told judges, what do people think of your case management style, and not just grade it on a scale of 1 to 10. And tell you anything like what's good, what's bad, what's indifferent. How are you when you preside over trials? Or do people think they're being treated fairly even if they lose? I mean, there's ways that people in kind of high-level professions can get evaluated, but there's really not anybody out there doing it on any kind of a regular basis. And honestly, because it's hard to do, and if you're going to do it right, it's really hard to do it right, and not have it just be, a series of gripe sessions, or on the other hand, a series of, suck up sessions. But that's, 10 years ago, 12 years ago, a local bar association did it's every 25 years, or whether we need to or not, review of federal judges. And I found some helpful stuff in there, not some of it, not all of it great. And I, try to take it to heart, and some of which zebra can't change their stripes, but yeah, it's just not happening. It's just not happening, and we don't have, and again, probably because it would be so difficult to do. We don't have, like you would have at a big corporation, somebody who's doing kind of a regular review of you. Like who would do that, and how would they do it? I have no idea. I mean, somebody could figure it out, but how to do it, but it would have to be its own kind of apparatus, and anything that comes from the government costs money, and somebody's got to pay for it, and there's no real desire to pay for it. Now, as a federal judiciary, we get criticized from time to time not having kind of an ombudsman or something like that, but that tends to be about the sort of really egregious type of situations, like, people making racist, gender-biased comments, corruption, quasi-corruption, things like that, and kind of the outlier cases. And every time you have one of those, somebody says there needs to be kind of an inspector general or something like that. But we got, I don't know what the number is, like 500 federal district judges around the country. I mean, how are you going to evaluate all those people? It's really tough. Who's going to do it? How are they going to put together the study, it would have to be a significant number of people. Probably that would be their whole job, and we just don't have it.
Well, let's say in a fantasy land, and you've drafted many local rules. So let's say you drafted a local rule requiring counsel to give feedback, at the end of the resolution of litigation. So what's a couple questions that you would put in there?
Yeah, I mean, I'm just thinking about the last time I got something from you could do the hotels.com kind of smiley face, sad face. How was that experience? That's not helpful at all. I mean, you ask a question like that, and I suppose I could think of something, and I'm a lawyer. I immediately start thinking about why this would be a waste of time, because if the experience was okay, or or even positive, I mean, how many people are going to do that if the experience is negative? I mean, by definition in my job, half the people go away dissatisfied, or if I have to decide a case. And how would you know whether, the fact that a person lost is tainting their decision, tainting their evaluation? I'm not sure. That's why I say I think it would have to be done on a systematic basis by somebody who knows how to, filter evaluations and try to control for, dissatisfaction with the outcome in evaluating the process, because the process is what you want to get evaluated on. I mean, I get evaluated on whether my decisions are good or not by the Court of Appeals, I guess. It's a small percentage of cases that are appealed, but that's an evaluation of sorts. That's not what I'm talking about. I'm talking about the process.
Yeah,
the short answer is I don't know.
Well, my take on that is, let's say I resolve the procedural hurdles to getting compliance, and now we're just in a world where you can get compliance, you can get the information. I suppose we could focus on that.
Yeah, well, so what I'd want to know is, did you feel you had a chance to make your point? Did you feel that the judge listened to your point? Did you feel that the judge took your views into account? Not, did you like the outcome? I mean, like I say, the appellate process works for that. Was there things that the judge did that you think were, counterproductive? Things that the judge did that you thought were particularly productive or helpful? But a series of the kinds of things you get on your average, web interview, where it's like, rate this on a scale of 1 to 10. I mean, that's just, it's not great. You need specific stuff. I mean, because I'll just tell you, like I said, before after I got appointed and before I started, I went around and talked to maybe a dozen judges in our district about, their techniques for this, that, and the next thing. How do you pick a jury? How do you do this? How do you do that? I got to tell you, with maybe 1 or 2 exceptions, first of all, they all had different ways of doing things, and they all said, and the lawyers love the way I do it. And I had to hold my tongue on about half of them, because I wanted to say, no, we don't, because I knew we didn't. But I'm not going to say that, and nobody else did either, and that's why they all thought that everything was copacetic. And so that's what you get. And so, but getting the opposite of that is like, this person's an ogre, which is what web interviews or web reviews, often descend into. Not helpful. I mean, except at some very general level. So you need something detailed about, what was. Did you feel like you got treated fairly? Did you feel like you had an opportunity to make your points? Did you feel like the judge actually considered your points? If not, why don't you think that? What do you think could have been done differently? What was good? And I mean, you could design, if you were good at this kind of thing, which I'm not. You could design a survey that would work, I think, at some level, and then you'd have to get people to do it. There'd have to be a sufficient compliance rate among the lawyers and the litigants to, so that you're not just getting kind of the outliers on one side or another, the people that think that you walk on water and the people that think that you walk around with a pitchfork or something. But yeah.
Yeah, that makes a lot of sense. And yes, I've seen, I think, some of the kinds of websites you're describing. And yeah, unfortunately, with this pool of information, I think it tends to be a lot of disgruntled people currently is the closest thing of rating. And it's not unique to judges. There's other
Oh,
domain,
sure.
what you see, like, with I think doctors, I feel like if you
Right.
Google it, it's mostly negative reviews.
Yeah.
So yeah, I understand that, but I think that is an interesting problem to be solved. Well, going back to, you were talking earlier
And I
about.
would say, let me just say, the logical, this is not going to get done by, we're the government, okay? This isn't going to get done by the government itself. It's just there's no appetite or money to put the resources into it. If it's going to get done, it's going to get done by bar associations. That's who does this kind of thing. And the problem with it is it's a massive, if you're in a place that's got big courts like we do, it's a massive undertaking. It could be very much a full-time job. And the resources that you'd have to commit to it are if you're going to do it right in a way that's helpful. In other words, you're not just trying to, to wave the red flag in front of the people you hate. You're trying to give people helpful feedback. It's a very massive undertaking, I think, or at least could be.
Yeah.
Anyway, sorry for interrupting.
No, that's a good point. So going back, we started this conversation talking about how judges are this kind of last bastion of the generalists. And I'm interested in that for a variety of reasons. That's what it seems to me, and that's something that's fascinating about the role. Maybe some CEOs, if you're Jeff Bezos and your company touches on so many aspects of society, that you are seeing wide swath of society through that role as well. But I think something that interests me about the role is, we talked in context of being this generalist and the variety of the docket that you have. There's some that necessarily entails case management, and then the case management techniques you have. Maybe we can go into a little more substantively. So by virtue of being this generalist, you have to get an understanding of so many different kinds of subject matter. So what are the patterns of digesting this information and honing in on the things that matter, because it's inconceivable that you're spending, you're trying to master every single detail and nuance. There has to be some things that are naturally more important than others, and things that you've learned to hone in on. And so can we talk some more about some of the techniques underlying the substantive aspect of drinking from this fire hose and processing it?
Yeah, I mean, and I wish I could reduce that to a formula, but I really can't. I mean, it's one of the things that if you, as a lawyer, as a practicing lawyer, if you have any kind of a complex practice at all, one of the things you learn is that you have to be able to filter out what's important from what's unimportant. I mean, if you're working for a 1,000 lawyer firm that only defends Fortune 50 companies, then maybe you don't have to have that filter, because you can do everything for everybody all the time because they'll pay for it. But in most legal practices, you have to develop the skill of being able to figure out what's important. And honestly, you don't always get it right. And I think that's true even now. So you're right. I mean, drinking from a fire hose is probably a pretty good analogy for what I do. And today I might be dealing with a complicated patent dispute about, some sort of chemical formula. And tomorrow I may be dealing with the question of whether a person who's charged with a crime and mentally ill is competent to stand trial. And the next day I might be dealing with some complicated question of insurance law and interpreting, very complicated language in insurance policies. And it's like you're going from one thing to another. And for I think for most of us in this job, that's kind of the great thing about the job. You're not doing anything the same way twice. But, jack of all trades probably means master of none. And that's, and I mean, that's certainly true. I wish I could reduce this to some kind of a formula, because it's a pretty common question. I mean, I speak to law school classes and things like that. You get asked a similar question, and I mean, it's the same way people kind of figure out other things. You read and you listen, and you read and you listen, and you think and you set it aside, and you come back and if you have to issue a decision, you start writing a decision. If it doesn't work, you set it aside or you go the other way. And I'd like to say, I mean, I clerked for a federal district judge like me, 40 years ago, and one of my co-clerks was somebody who was completely brilliant, and the way he would go about deciding and drafting decisions, it was all somehow getting done in his head, and then he'd just start making outlines on a paper, and it would flow from one to the next. Like, I think I'm a reasonably intelligent person. I could never do that. I mean, for me, it's almost like trial and error. And what I actually tell people, I mean, I speak to a class regularly of judicial interns in law school. So these are law students, usually first or second year, who are working for a judge and kind of acting as junior law clerks and helping the judge decide cases and writing memos. And I tell them, what's going to happen when you're working on an assignment is you're going to read one side's submission, you're going to say, wow, that sounds really persuasive. And then you're going to read the other side's submission. You're going to say, wow, that sounds really persuasive. Then you're going to read the first side's response to that, and you're going to say, wow, that sounds really persuasive. Now what the hell do I do? And the first thing I tell people is don't panic, because that happens to me too. And I've been a lawyer for 40 years and a judge for 21. It's normal. It's supposed to work that way. If it was that easy to decide, I wouldn't need to have you work on it. And so you work through those problems the same way people work through problems in life. As you think about it, you listen, you try to work it out, you see if the resolution works. If it doesn't work, you try something else. And in the long run, I mean, what I tell people is, look, this is what you do. If all else fails, I mean, you've sat there and you've reasoned it out and you've outlined and you've tried to go from point A to point B to point C to point D, and you still get to a point where you've got to decide between two competing visions of how something should come out, and you can't figure out how to do it. So I say, look, do what I do. Because that happens to me. It happened to me, 2 days ago, all right, on something. And like I say, I'm in my 41st year as a lawyer. So I say, okay, I can't figure this out. And I've reached the point now where I just can't keep tossing it around in my mind. I got to make a decision. So I'm going to say, okay, this side wins. I'm going to start writing it that way. And I start writing the decision. And if you're thinking about it in a logical way, and as your math teachers used to say, if you're showing your work and you're going through all the steps, if that's the wrong decision, at some point you're going to hit a wall, and you're going to know that you hit the wall, and you're going to say, you know what? This should come out the other way. And if you never hit that wall, it probably means it's the right way. And one way or another, the process of just having to commit it to writing is going to help you decide it. And that's what I have found. And so I have to deal with, you're right. I mean, I deal with stuff that I don't know. I don't know the first thing about, I'm dealing with a patent case right now about MRI technology. All I know about MRI technology is sitting in one of those machines and having it be real loud. That's all I know about it. And so I'm not a neurologist. I'm not a person who designs MRI machines. I'm not a radiologist. I'm not any of those things. But one of the things I've learned over the course of 40 years of practicing in areas that I didn't know the underlying subject matter and being a judge is that, you just do your best to, at some level, there's a logic to everything, and you just kind of got to figure out where it is. And you read as much as you can, and you learn as much as you can, and you try to make sure that you hope that you know as much as anybody in the room, or at least have read as much as anybody in the room, and do your best, and hope that and try to make it make sense from a common sense standpoint. And if it does, there's a good chance it's going to be right.
Is there a division of labor, or I don't know if this is the way you think about it, but I wonder if you see a difference between understanding the case and then deciding the case, and if you do, is one more challenging than the other?
Yeah, I'm not sure that there's a real dichotomy between the two things, because you have to have some understanding to be able to decide it. I mean, if you don't, it's basically amounts to a kind of a glorified exercise in coin flipping, which you really don't want to do, and I think everybody tries not to do. So you have to have some level of understanding, and so I think they really kind of go hand in hand.
Yeah, I guess what I meant is those are probably two phases, and I wondered if you felt,
oh, I see.
And then you decide, and I wondered if you felt like one phase was more difficult than the other.
Yeah, so I guess my pushback would be I'm not sure they're distinct phases. Mm-hmm. I mean, I think for me, I think they kind of happen at the same time, and that may go back to the I Love Lucy analogy. They kind of have to. Mm. I don't have the luxury of saying, okay, I'm going to put everything aside for the next 2 weeks and just do this. I mean, I guess I do that in a sense when I have a trial going on, but even then there's before and after, and I have to do other stuff during the lunch break and things like that. I really don't have the luxury of saying, okay, there's only one problem in the world, I'm going to deal with it, except for little chunks of time. I mean, when I'm working on this, I'm not working on that, obviously, but I don't have I don't think, and this is one of the differences I think between what trial judges do and what appellate level judges do, is you do not, generally speaking, you don't have either the resources or the time, given the relative volumes, to spend overwhelming amounts of time on a single thing. On the other hand, except when you have to, which is, the exception that proves the rule. So every now and then you get something, and I had one last spring, where it's a kind of, this is more important than anything else you're doing. You got to drop everything and just work on this for 2 weeks. And I mean, that happens every now and then, but it's relatively rare, and at my level at least.
Yeah, I think, for my time, externing for, 2 judges in law school and, my experience in court, I have an understanding that a huge part of a federal judge's job is being efficient with time, like you're describing. And, I think now talking about a more enhanced understanding what that looks like. But, with it, and I think it's kind of interesting because I think so few people associate government with efficiency, but I think that this is one of the roles where, government has to be very efficient, is by convention or standard. So I'm interested in application. So how do you decide? I think at some level we understand that, this patent case you're describing will require some level of more time spent understanding, deciding, than say a very simple, slip and fall case. And so how, can you give us some sense of the heuristics you're using to allocate your time and energy to the cases based on, say, their complexity or,
Yeah, I want to think about that for a second. So there's a bunch of different kind of tracks going at the same time. So I've got stuff that parties are submitting written submissions on that has to be decided. I've got kind of the day-to-day stuff that I'm kind of deciding at the snap of a finger, at the blink of an eye, which tends to be the sort of less consequential things that are not terribly complicated. I've got the longer-term stuff that, I know that this case has a trial date and such a date, so whatever I'm going to do before that has to happen before that, unless I want to move the trial date. And then I have this trial, and there's all this stuff that I'm going to have to do around the trial. So it's for me, and I guess I consider myself organized, but maybe in a disorganized way, if that makes any sense. It's to a certain extent, it's not that the squeaky wheel gets the grease, it's that the wheel that is about to go over the cliff has got to get the grease, or has got to get the brake. I'm just mixing my metaphors there. And so a lot of the kind of sorting out of what I'm going to work on a given day is kind of depend on what's the most pressing at the moment. So I'm like anybody else. I may go into work with a list of 8 things that I really want to get those 8 things done today. And if I get 2 of them done, I think, my God, this was a massive win. I got two out of my 8 things done. How did I decide it was those 2? Well, okay, so today, for example, I had a hearing on a case that had to happen at a certain amount of time, at a certain point in time. And yeah, I'm the judge, so I could move the hearing, but I didn't. And so there was certain stuff that I had to get done before this morning so I could be ready for that hearing. I've got, next week I'm on a committee that's, I've got to give a presentation at a meeting. And so, before that meeting, which I don't have any control over, its scheduling, I'm going to have to set aside a certain amount of time to get ready to present at that meeting. So a lot of it is just kind of that simple. It's whatever happens to be most pressing. But then what you have to do kind of in the background, and again, there are trial judges who are more or less directly involved in this themselves. But what I'm also doing is, as I put it, in the background, kind of making sure that the 30 new cases I got last month, that something's happening in those cases, that deadlines are being set, or somebody's being told, okay, you're going to have a case management conference on such and such a date, so that everything has. What I try to do, and one of the things I learned from other people when I started the job, was try to make sure that everything has some sort of a date or a deadline. Because the last thing you want to have happen is to have stuff start slipping through the cracks. Now, you can always move the date or the deadline, but make sure everything has one. And so then a lot of it becomes kind of it's just really mundane, I know, kind of an exercise into, okay, I got all these deadlines, which are the ones that I can move, which are the ones that I can't move, which are the ones that I really, really can't move, because this is really, really got to be done right now. So for example, during the last 10 months, 11 months, because of the pandemic and because of some changes in the law, we now have, as district judges, the authority to do what some people call a second look on sentences. And so we've gotten this flood of requests from people who are in prison that I've put in prison, or that some judge who's now retired put in prison and I got assigned their case, saying, I'm going to die in here, let me out. And I've done enough time. And obviously those things are more pressing. They have to go to the top of the list. Now, do all of them go to the very top of the list? No, they don't. Sometimes they don't. Sometimes you may look at that and say, maybe not right now, but maybe in another 6 months I'd consider this. So maybe you put that on the back burner. So there's some things that kind of naturally have to go to the top of the list. I had this big case last spring that involved, the pandemic and how that was affecting people in a local jail. And because of the way that was presented to me, that was a drop everything, all hands on deck, everything's got to stop for the next X number of weeks so that we can get this decided. And so some of the prioritization is happening that way. And so I wish I could tell you that I could hear, I'm going to turn the camera around and there's my flow chart on the wall. It tells I don't have anything like it would be crazy looking. It would be one of those, cop shows on TV where they go into the crazy person's basement and they've got like 500 things up on the wall with strings between them. That's what it would look like. So it would be scary and probably not a good thing for anybody to see.
Well, it seems like that's a funny way to put it. I'm sure there's some things that are more systematized about it. Yeah, I think that's such.
Well, yes, okay, there are. Sure, there are.
Yeah.
So X number of days after a case comes in, I need to make sure that I have set a deadline for somebody to get that case going. When a criminal case comes in, particularly if the person's in custody, when the first time they come in, I'm actually going to set that criminal case for trial, because with criminal cases, we need to know that there's an end date. If I have a case that I know is going to go to trial, there's certain things that have to happen before the trial, and I know what all those are, and I'm going to set deadlines for all of those. Everything else, it tends to be more case dependent or situation dependent.
One thing that I haven't got a sense of is, I imagine the answer is yes, you do enjoy this, but do you enjoy writing opinions?
Yeah, I do. I don't. So as I said before, we have law clerks, and again, they're lawyers who basically act as the judge's lawyer. As the judge's lawyer, you're advising the client, namely the judge, on how he or she should decide a case. They help us, filter stuff, come up with recommended decisions, and different judges have a different degree of involvement in that process. I actually do some of the decision writing completely by myself without law clerks. And part of that is because, I may have 2 law clerks working on this really super complicated stuff that I don't want to pull them off of, that I really don't want to do from scratch myself. And then there's this other thing going on over here, and I've just realized that that's got to get decided in the next week. So I say, fine, I'm going to do that myself. Sometimes it's just because I like to. And I mean, for me, the process of kind of solving a difficult problem, it was one of the more satisfying things about practicing law for me, and one of the more, satisfying things as a judge is kind of working your way through a difficult problem and trying to come up with a just and reasonable resolution for it.
Do you have a favorite literary reference that you've inserted into an opinion?
No, although I will say that I quoted, I referred to Bob Beamon in the 1968 Olympics the other day, and I actually on the phone yesterday quoted Hyman Roth from The Godfather, where he says to Michael Corleone, "This is the business we've chosen." Not "this is the life we've chosen." That's the way it commonly gets quoted. "This is the business we've chosen." I said that to a very successful, very skilled criminal defense lawyer who always has too much to do and was basically complaining he wasn't going to have enough time between some other trial and my trial. And I basically said, I'm going to quote Hyman Roth from The Godfather, "This is the business you've chosen."
That's very impressive. I'm a big fan of Godfather too, and that's not the line I would have plucked out of thin air if I was going to make a reference to it. So that's a good insider one. Well, I actually did see your baseball line because actually it was profiled in Docket Navigator. I don't know if you knew that, but
Say what?
in
Okay.
Docket Navigator, yeah. So, well, that's kind of funny. I think something that'll be interesting to pick up on that you were talking about earlier. I think we've talked about it in a couple different ways, but I think you've really underscored the experiences you had before you were on the bench, the distinct practice you had where you had both a civil and criminal docket. And so you really touched on so many kinds of matters and really gave you a really broad understanding of what the rule entailed. And I just think it sounds like that's a unique experience that not many other judges had. So can we talk a little bit about, the impact of the diversity of experiences someone has? And we can talk about diversity as broadly as we can, beyond substantive. We can talk about backgrounds as well. So what are the ways that you feel that, diversity of all kinds is beneficial to the bench, and what are the things to do to facilitate that?
Well, so, no one person can be completely diverse by him or herself. And so when you talk about having a diverse bench, not everybody is, there's that means that you have this person from this background and this person from that background and so on. The theory, at least part of the theory, kind of the looking out theory, or one part of the theory is that to the extent that judges learn from each other, if you have that diversity of experience, then judges will be able to learn from people with various perspectives. Now, how much judges pick up and learn from each other, I think there's no systematized way for that to happen. We have, a couple of the judges on our court in recent years have reinstitutionalized something that existed back in the early 80s when I was a law clerk, which had to do with sentencing. I keep coming back to sentencing, but again, the most difficult and probably most consequential thing that we do as judges. And the way it works is that we have a meeting every Monday and over lunch, and any judge in this group, and the group can be any judge in the court can submit a case for that they're going to have a sentencing hearing in, and you submit all the paperwork, what we call the pre-sentence report, the parties' sentencing briefs, whatever else you've got, you submit it to them, and everybody else looks at it, and then we kind of go around the room, and each judge, or I guess not around the room, around the Zoom, I guess, at this point. And each judge kind of says, well, this is what I think about this case, and this is the sentence that I would impose if it were my case, and here's why I would do that. And you kind of go around the room and you get different perspectives. And so when this got reinstituted, there had been various efforts over the years to do this. This is something that existed when I was a law clerk. So back in the early 80s, there was a regular group that would actually meet in my judge's office every Monday afternoon because he was the most senior of this group, and that's what they do, exactly the same thing. And it had kind of fallen away, and particularly with the mandatory sentencing guidelines, it had kind of fallen away because it didn't matter as much anymore. And there had been some efforts over the year to reinstitute it, and my concern would be, well, if you needed to have a sufficient diversity of views and backgrounds and attitudes on this group for it to be meaningful. Otherwise, it's all just going to drive in one direction, either one way or another. And I think we've kind of got that at this point. We've tried to. It's a good tool, if you will, for as we have new judges come on our court. Not everybody has had experience in the criminal field, and even those that haven't sentenced anybody. And we've kind of, as part of our orientation, we've kind of marketed it to the new judges, like, you really should come join this group, and it's beneficial. And like I said, I've been doing this 21 years, and I still find it beneficial, even though I've sentenced, hundreds and hundreds of people over the years. So now I've completely forgotten what your question is, but I think that was a response to it. Do you remember what your question was?
Oh, that's a good question.
I got you there. So both of us forgot your question. All right.
Well, here's how I put it. I was opening up the floor to talk about diversity in a broad way.
Yeah, diversity. Okay, so that my point there was that if you have judges from different backgrounds and they are communicating with each other, then that's beneficial, because I'm going to see how somebody who was a career prosecutor looked at this case, and I'm going to see how somebody who's a career defense lawyer looked at this case. I'm going to see how somebody who's a career civil litigator who didn't do any criminal cases looks at this case. Somebody from, who comes from this walk of life or that walk of life. So internally, if there are judges, and thank God we have a couple on our court who've kind of kept this thing going, not myself, other people. If you have judges who are willing to kind of create those mechanisms and keep them running in some sort of systematized way, you have that kind of feedback. So that's one aspect of diversity. The other aspect is, it's kind of the obvious. It's you don't, and again, particularly in the criminal field, if a person of color, comes out of the holding cell at the side and the whole courtroom is full of old white men, it kind of gives you a bad feeling, is that person. And yeah, some of the judges are going to be old white men, but not all of them have to be, and not all of them should be. And so from a public facing standpoint, that as a court, if we, to kind of quote a hackneyed old phrase, if we look like America, that's going to be good in terms of public confidence in the judicial system, that it's a diverse group of people, that are out there resolving your disputes, and not just a bunch of rich guys that, are dabbling in this in their twilight years.
Yeah, I think there's a bunch of ways we can jump off that, but one way I want to jump off it is, you've mentioned several times about the difficult nature of sentencing, and some of the changes with the second look, the opportunities that this is giving you for reflection. And so one question I have for you is, what is difficult? I've got an intuitive sense about what's difficult. It's difficult to, someone in prison, and then maybe it's difficult to determine how much it is based on factors like you were talking about, as does this person have a family? Did this person contribute to society in some other way? So that's intuitive, but what are some things that people don't?
So the thing that's difficult about it is like many things we do as judges, it's a question that doesn't have a right answer. It doesn't have a right answer. There's nobody that can come and say that, that can come and say with a straight face that for this is the right sentence. There's many answers to that question. And that's part of what makes it difficult. The other part of what makes it difficult is that, you're standing there looking at this person, and you're looking at all of what's behind them, and you're looking at their victims. If it's a crime that has victims, and you're thinking about, how does this affect all of these people, not just this person here, but his family, his victims, other people who might be affected by it. And then it's also difficult from the standpoint that it's very easy to say, just bang the gavel. Although, by the way, nobody has ever done that, bang the gavel, in the entire time that I have been a lawyer and a judge. I've never seen any judge bang a gavel except on TV. But it's very easy to just go out there and figuratively bang the gavel and say, 20 years. But if there's any kind of level of humanity in you, you have to understand that that's a meaningful thing, that you think about. Okay, what I'm doing here is I'm saying that for the next X, this person is going to live in a cell. Everything they do is going to be watched. Everything they do is going to be controlled. They're not going to be able to leave, even if it's a so-called club fed. There's a fence on the outside. They can't go away. They can't pick what they want to eat for lunch. They can't pick when they're going to have a shower. They can't pick whether they're going to have a shower. They can't, decide that I'm going to go up the street and get a cup of coffee. They can't say, well, I'm going to go out, and jog 5 miles right now because it's not your time in the yard or whatever. And it's a very consequential thing. And so if you think about any of that, is one of our more senior judges, once said, is like if you're doing it right, any sentencing takes a little bit out of you. and it does. So, and if you're doing it right, means that if you're really thinking about all that stuff, now you're also thinking about the victim, and you're also thinking about the future victims. If they're, if this is somebody who you think might do something again, you got to think about all that stuff. And it's like I say, it's something that doesn't have a right answer. It did, I guess, when we had mandatory sentencing guidelines, which is why I say in my view, perverse way, it was easier then. But there's no training. They do courses in sentencing. They do, but they can't tell you that how to what's the right sentence for the guy who just robbed a bank, gave somebody a note saying, if you don't give me all the money, I'm going to blow your head off. I mean, what's the right sentence for that? I don't know. Is it 5 years? Is it 10 years? Is it 20 years? Is it a year and a half? Is it probation with a lot of mental health counseling and drug counseling? I don't know.
So you mentioned
depends. So
it depends. So you mentioned that this kind of premise of if you're doing it right, it takes something out of you. So then, what recharges you? What is it that sustains you? What aspect of the role, is it? And I wonder if it's there's different ways to answer this. Maybe one way to answer it is it something about the substantive aspect of the work? Is it something about how you see it affects the parties? Is it something about how you feel this affects the public in general and how justice is administered? Is it something about how you interact with your team? I mean, what are the things that?
Yeah, I mean, it's a lot of those things. I mean, I think in part it's the knowledge and the awareness that you're important. You're carrying out this very important public function that's necessary for our type of society to continue to exist, so that we're not just fighting all these things out in the street somewhere. I think it's the satisfaction with having done a thoughtful and thorough job on whatever it is that you're working on. I think it's on a completely different level, the ability to to supervise and shepherd and mentor younger lawyers who work for you. It's a lot of things like that. So it's not any one thing. It's a lot of things, but I mean, it is a satisfying job. It doesn't mean that every moment of it is fun. A lot of it's not.
So you talked about, when we're talking about diversity earlier, you were talking about the importance of the public-facing component of the judge's role. And, something that is strange about the role of a federal judge compared to counterparts in other branches of government is, counterparts in the executive branch, the cabinet, or the legislative branch, there's plenty of attention on senators and congresspeople. So, in relative terms, district court judges are infinitely smaller amount of attention put on them. I mean, I think, if we walked on Jackson Avenue right in front of Dirksen and asked people, can you name one federal judge? I'd be curious to see what the survey results are. So I'm curious, I guess at an initial level, we can just talk about how does that make you, what's your reaction to that? Is that something that is, we can use feature or bug as a construct, or, as an initial impression, what do you think about the fact that an individual district court judge gets so little attention, scrutiny?
Well, I'll tell you what. I mean, I think that part of that is, we're very geographically specific here. So you and I live in a city where, like I said, on my court there's 45 or so judges, and then in the same building there's 15 or 20 bankruptcy judges, and in the same building there's another 15 or so appellate judges, and I'm not going to say we're a dime a dozen, but there's a lot of us. And so there's a few people that somebody may say, oh yeah, I know about Richard Posner or something like that, because of they're a more prominent person. But if I'm in small town USA, it's a one judge court, I don't know. Maybe the local federal judge in that town is somebody that everybody knows who they are, and when they walk down the street, some people say "top of the morning" to you, Judge, and tip their hats or whatever. So I think part of it is that. I think aside from that, though, we don't get recognized, but we I really think that of the branches of government, what we do is way more transparent than any of them, because we have to explain our decisions. Like when Representative so-and-so is voting on this bill or that bill, he doesn't have to issue a written opinion saying why I voted on it. I do. There's a rule that says I do. So I have to explain it. And largely what we do happens in the open. There's no backroom meetings with lobbyists. Not that I'm critical of that, but there's no backroom meetings with lobbyists. It's all happening on a record. Somebody's taken it down. It's illegal for somebody to have a separate meeting with you. So we're much more transparent than I think any of the other arms of government in that way. Yeah, I mean, does somebody know who this or particular judge is? No, but they know that we have this system out there that, they're reading about every day, where somebody says, yeah, okay, I'm letting this person out on bond or I'm not, and here's why. And you get to, if you're paying attention, you get to see all that stuff. And it's, to me, it's a terrific feature of the, and not just to me, to everybody, it's a terrific feature of the system that it's all done in this very transparent way. So, yeah, I don't care if I get recognized walking down the street or not. I think in some ways it's kind of a good thing, because half the people would be saying, well, that was a boneheaded decision you issued in that personal injury case the other day. What the hell were you thinking about when you did that?
Isn't that feedback you said you wanted?
Not that, no, because that's not the organized, systematized, analysis. That's just somebody, reacting to, what they saw on Twitter, or whatever. But, that wouldn't be bad either. I could, but the problem is I can't talk about it with them. So I just say, thank you very much. Nice to see you. And just let me get out of here really fast.
It's interesting because I think a recurring theme that we're talking about is the benefits and the consequences, or the drawbacks, of judges being these kind of, as you're saying, these like individual law firms, or however you want to put them. There's benefits to this, let 1,000 flowers bloom kind of approach. But then also maybe it seems to me some missed opportunities for making things more efficient and systematic and fair, possibly recognizing that we, some of the nuance we talked about that, different matters require. But then also I think it ties into, the issue of, broadly speaking, of overseeing judicial conduct. So you're referencing, the lack of something like an ombudsman or inspector general kind of aspect, and that so much of the regulation of judicial conduct happens to the appellate mechanism. But you're also noting earlier that there's any number of decisions you make that are, almost insulated from that, given the level.
That's true.
The amount of deference given. So it seems to me that something we're talking about in a variety of contexts, say intra-Northern District, between litigants in the court, between the public and the court, it seems like there's some maybe missed opportunities for feedback loops to get it more information. It ties even into your comment about avoiding robitis. So yeah, it seems to me that this is not exactly we're not going to come up with a solution right now. There's definitely a lot of nuance to the problem, but kind of the theme, I should say. But I'm just curious about the ways in which you think there's opportunities for more of a public engagement in the role of the district court, because I think ultimately that affects things like, say, how district courts are judged and confirmed, and we can talk some more about that process too. But yeah, maybe we can just start with that, unless there's more thoughts you have on this issue. But
not really. I think on that. I think as we've talked about it here, it seems to me that there really, it really falls on the. You're not going to expect John Q and Jane Q public to do that. They don't have the time. They don't have the tools, the background, the knowledge. It really falls on the organized bar to provide, or to come up with mechanisms for providing feedback to people. And I recognize that it's a massive undertaking, and so it's not likely to happen in any great way. And because the feedback that we get, which is reversed, affirmed by the Court of Appeals, it's a slice of what we do. Did you make the right decision or the wrong decision in this particular situation? But it's only a slice. The case management stuff that we're doing, that's not getting reviewed by anybody except at the extreme margins. I mean, I tell my new law clerks when I start that at least 90, if you think about all the decisions I have to make, at least 95% of them are effectively unreviewable, either because they're just plain unreviewable, or because they're just never going to get appealed, or because if they do get appealed, the standard of review is so deferential on appeal. And it's this very tiny slice of things that are effectively reviewable on appeal. And then even then, there's all these disincentives to appeal, such as cost. So yeah, most of what the formalized review process of the substantive accuracy of your decisions is just a really narrow slice of what we do. And there's what you'd like to see coming, or what I'd like to see at least coming out of the organized bar is some way of doing that. And of course, there's all sorts of disincentives to do that too, because like, who's going to sign that document? You know, who's going to sign the document that says Judge so-and-so is a menace to society and you know is running roughshod over litigants in cases, and because that person is, and maybe it just gets signed by, you know, the local bar association, but there's somebody who's the president of that, and there's somebody who's the vice president, and somebody who's the chair of judicial evaluations, and are those people going to feel they don't have lifetime tenure? You know, and they got to appear in front of the people they're evaluating. So it's tough. I don't have a good answer for it.
Yeah. Let's talk a little more about the confirmation processes. The last time we talked, you're kind of noting about some of the ways in which that's changed in the time that you've been appointed. So tell me some more about the ways.
Yeah. So I mean, I think it's pretty much conventional wisdom that, you know, up to a certain point in time, and let's put the point in time, let's say somewhere around the mid 90s. There was not a whole lot of serious scrutiny to federal district judge appointments, so trial level judges, partly because there were so many of them, partly because the perception was, what are they doing that's all that important? They're not setting precedent for anybody. It's not the Supreme Court. It's not the Court of Appeals. And so you would see the historically district judges got confirmed pretty quickly and without a lot of controversy, except at the extreme margins. And that's not the case anymore, and hasn't been the case for, you know, a few years before I went through the process. And I think it's partly because of, you know, a lot more, you know, you can take this one way or another, but, you know, over the years it's become perceived what a significant role the judiciary has in, I'm not going to say political decisions, but policy decisions. And it's normal, I think, that there would be more scrutiny as that's perceived to be a thing. And I think there's probably a greater level of awareness that even though people like me aren't issuing the final decision on anything, we do set the table, so to speak. And you know, maybe some people at my level end up moving up to the upper levels, and so we ought to pay attention to these people before they get too, you know, ensconced. And I think that's true on both sides of whatever aisle you're talking about. So there's just a lot more scrutiny of it now. I mean, you didn't have district judge appointments getting held up in the old days. It just matter. I mean, the local senator would suggest somebody to the president. The president, you know, would pretty much say that. What do I know about, you know, the district court in Keokuk, Iowa? You know, I'm going to go with what Senator so-and-so says because he lives there. And so there wasn't a lot of scrutiny at that level. And then, you know, the person to get in front of the Judiciary Committee, and it's a district judge, and, you know, unless there was, you know, something really bad in their background, they would kind of fly through, and that would be the end of it. So then that changed, and it changed, I think, largely for what people would call political reasons. I say on both sides, and I can't be critical of that because, you know, it's certainly true that in some, I would say, extremely tiny percentage of cases, you know, some case I have is going to have some greater impact on society. I think that's a really tiny slice of what I do in any practical way. But so that's all changed, and it's, district judge, and it is still not as controversial, tend not to be as controversial as appellate nominations, and certainly not as Supreme Court. But it tends to be a lot more scrutiny given to them, and a lot more situations where people are held up for one reason or another, or have to get their nominations pulled, or something else like that happens.
Now, in the interest of for the benefit of the judiciary and the quality of the people that are selected, or what are the things that you wish that the general public would ask more of their senators, or expect from their elected officials as part of the selection process for judges? What are the ways you think the general public?
Well, I guess what I would say is, I can't blame anybody in the general populace for thinking this, because it's kind of what gets drummed into people. But please don't look. So my job involves processing cases, involves deciding cases, but involves processing cases. It involves case management. It involves getting people to do things they don't want to do when they don't want to do them. And it involves, giving people kind of a fair process by which their cases are going to get decided, and give them an opportunity to do all that. And so please don't pick people like me about how you think I'm going to vote on, like, the burning issue of the day, because number one, I'm probably never going to have to decide that case. And number two, even if I do, it's going to get reviewed at least one, maybe two levels above me, and that is 0.1% at most of what I do. And so what you ought to be looking at is, are you appointing somebody who has kind of the background and skill to be able to learn in the job, and not get sort of highfalutin view of themselves, where they're marching around like the Lord and Master of the universe, and that's what you ought to be focused on. So breadth of experience, ability to deal with different types of situations, ability to listen. What is it in their background that gives you the ability to do that? People from different kinds of backgrounds, practice backgrounds, life experience backgrounds, and so on. That's what people ought to be looking at. And I think, honestly, I think to a large extent that still happens. Okay. And I don't get me wrong. I'm not saying that the process is broken or anything close to it. I don't think it is. There's a lot more scrutiny, but I just think that, we're as human beings living in society, we're kind of driven to think about everything as black and white or red and blue or whatever you want to call it. And there's a lot more to my job than that. I mean, as I said, I have a lot more. I mean, although I got appointed by a different president, I have a lot more in common with somebody. I got appointed by a President Clinton. I have a lot more in common with a district judge that got appointed by President Reagan, than anybody would think, because we're doing the same. We're managing this fire hose of information that's coming out, and we're managing this, herd of cats that are called lawyers that are dealing with this. And yeah, we might decide this case or that case in a different way, but we're largely seeing the same types of things, and we're in a problem-solving business. We're not in a business about, making the marquee decision that's going to be the thing that it's reported on the 5:30, national news today. That's not the enterprise.
So, connecting some dots. So, we've emphasized this case management approach and how much just the raw 30 cases a month, how much that constrains the decisions the judge makes. There's these federal rules of civil procedure, and there's all these aspects of the judge's role that is just really just about managing this flow of material. And that's going to be you're selecting for anyone who can do that. I'm also trying to connect the dot to what you said is the most difficult part of the role, which is sentencing. And, based on the, necessarily you're saying, a key part of that is weighing information about, the seriousness of the offense and the context in which it was conducted. And so that seems to me that necessarily that's drawing on life experiences, perspectives, backgrounds that differ. And so I'm trying to think about, how to reconcile those two, where it does seem like there's a major need to have people who are sensitive to different walks of life. And kind of the hard part about that is, to what extent that information gets pooled or, makes its way horizontally to other district court judges. As you're saying, there's a mechanism for that to flow upwards. Right. And maybe some of those appellate court judges flow down to other district court judges' requirements through issuance of an opinion. But so I think that's one thing I'm trying to make sense of. Maybe I can pause there. We can pick up with the next part of that question.
So, that's the problem. The horizontal flow of information, we don't have a good mechanism for that. And, maybe we should. Maybe what we've got right now is we have judicial conferences and we have seminars and we have these kind of informal groups like the one I described before that talks about sentencing, and we have, bench bar meetings, and, many judges are members of bar groups of one kind or another, Inns of Court, other types of bar groups. And so there's no formalized mechanism for it. It's all kind of, you get as much or as little of as you want. And I mean, there's plenty of judges who not interested and get none. And I mean, that's fine if that's what they want to do. But we don't have a good mechanism for that. We don't have any requirement in the federal system of continuing judicial education. It's available, but it's not required. I'm not sure. I mean, you have to take CLE as a lawyer. I mean, how good is some of that stuff? Who the heck knows? Don't answer that, because I'm the instructor on some of it. I'm not sure I want to know how unvaluable it is, but there's not a great system in place for that. And and anything you got to do, we could do it here. I mean, like I say, we got 21 active district judges, so on and so forth. If I'm in the 2-judge district, we're maybe having lunch together, but where else is the information flowing? I mean, that's just 2 of us. You'd like to get information from 14 other people. So I've gotten it over the years from being on committees that involve judges from other districts, being involved in things around here, being involved in, bar groups and going to meetings and being on, being part of continuing legal education and trying to listen to what I'm hearing, not just, like I say, getting up there and pontificating, but there's really no organized mechanism for it, and that's probably a fault.
Just an observation, you're talking earlier about, and of course, I think it is a fascinating and wonderful aspect of the judge's role is that they issue an opinion with the basis of their decision. And talking about the appellate mechanism for review, and talking about how that's just a sliver of all the decisions that you're making. But even in that sliver, the people that end up on as appellate court judges were district court judges. So that pipeline it seems to still affect
not all of them.
Okay, I mean that's okay.
But yeah, right.
Yes, but so I mean, jumping off that, so let's talk about it seems to me that there's so much about the role of the district court judge that, of course, I think even I would think the general public would think about this, but the litigants also think about that as much as judges are bound by rules. That of course so much of the role of the judge is discretion, and so we look to judges for their equitable wielding of that discretion. And so in view of the fact that you're saying that so little the decisions the judge makes are reviewable, what are the forces that kind of steer judges as a whole towards making the right calls, doing the right thing?
Yeah, I get it. So I guess my answer to that is if you're if you're paying attention to what you're doing and how it affects the cases. If you're really paying attention to that stuff, then you're learning from that. You're finding out that I did this, and you know what? I did this 5 times, it really didn't work. Or I did this 2 or 3 times and it did work. Let's try it in this other context. And what work means we could talk about, although I have a hard stop in about 10 minutes. But that's I guess what I would say. I mean, that's how you learn it. You learn it from paying attention to the effect on the case. And you're going to make mistakes. Some things are going to get screwed up. That's a fact of life. And you hope that, then you learn on the next case, I'm not going to make that same mistake again. Go ahead.
Yeah, one thing to pick up on, an application of it that I'm thinking of is, how is it that judges know what their blind spots are, or what are the ways in which
how does anybody know what their blind spots are?
Well,
I'm no different from anybody else.
Yeah, the specific context I have in mind is, there's no judicial rule that requires you, Judge Kennelly, to hire diverse clerks. Maybe people who have some sort of ethnic background or diversity, sexual orientation, you name the kind of diversity. But you do those things, right? So what makes you do those things?
Saying it's the right thing to do. And I think it's important. And I think, part of what I learned from when I was a law clerk is that it's this extraordinary opportunity to learn, and it's an extraordinary gateway into other things. And I try to give that opportunity to as many people as possible, and not all with the same background. And because if I did, I'd just be perpetuating the rest of the system just kind of looking like me. And so it's just because I think it's the right thing to do. I mean, no, there's no rule that requires me to do it. I mean, as a system, we get criticized, accurately for not being attentive enough to that, kind of on an overall basis. But I think in this day and age, most judges try to be attentive to it, and you don't succeed in each and every situation, but it's because most of us are in this not because this is just the cushy job that you want to put your feet up on the table and live out your golden years. By the way, if you did, it's a stupid decision because it's a hard job, but we're doing it because we have a commitment to service and a commitment to the system, and think that it's a good system, but always think that it can be improved, and that's one of the ways to improve it.
We talked a lot about, in some ways, reflections. So talking about, ways that you've changed or the bench has changed or, over time. And we talked a lot about the present, how you manage on a day-to-day, the things that come up for you. I'm curious to hear about, how do you think about the future? Say any given attorney in private practice is thinking about changes in trends, like, is the kind of work that I'm doing going to be in demand? Are my clients going to be in a good spot? Is there something else I need to be moving into? What are the things that you're thinking about, or maybe in general judges think about as far as prospective, maybe let's say on a year time horizon? What are the changes you're anticipating, or what are the ways you're thinking or looking?
Yeah, so you're if you're looking for the let's think some deep thoughts question, you're talking to the wrong guy. I mean, I'm more the nuts and bolts person, and what I'm thinking about is I'm thinking about the same thing everybody else is thinking about. We've had to change everything the way we do everything over the past year, and how much of that's going to stick, and how much of it's a permanent change, and how much of it is going to go flip back to the way it was, and so, and because again, maybe it's just because of my job or the fact that I'm suited for it in some perverse way. That's kind of what I'm thinking about. I'm not thinking about in 10 years are we all going to be working for Amazon or something, or all going to be delivering our decisions by drone or whatever. But so that's what I'm thinking about, and I think it's like in a lot of situations. I think the answer is that some stuff is never going to go back to the way it was, and in some ways it's going to be good, in some ways it's going to be, dang, that's a shame. But I wish I could give you the nice philosophical answer, but I really don't. I mean, I will say in the long term, I think it just in society at large, there is a view out there. I mean, again, I keep coming back to the criminal and sentencing, that as a country, we have tended to imprison too many people for too long. And I think over time, that's a long-term trend that I think is likely to continue. But aside from that, I mean, what I think the trends are in civil litigation, who the hell knows? I don't know. Sorry.
Final question then. So nuts and bolts, I know that you're a nuts and bolts person. So what is a nuts and bolts change that you've gone through right now that you're enjoying?
That I'm enjoying? Oh man, nothing. It's kind of stunk for the last 10 months. I much prefer, and I think in our court at least, because unlike most other federal district courts, we've been very much an in-person court. I mean, most federal district courts for years and years and years have operated by phone or just on paper, not seeing lawyers. I mean, I still remember the meeting I went to where I was on a committee, a judge's committee, and we went around the table, and there was a judge from a district in Florida. And I said, well, I'm so-and-so, I'm from the Northern District of Illinois. And he turned to me and says, oh, you're in that court where you guys see lawyers all the day. Why would you want to do that? Or you see lawyers every day. Why would you want to do that? And I said, like, because we like it, and it's human contact and so on. And so I think, that's gone away. And I think probably what's going to happen is that a lot of that's going to stick because, from just a cost and convenience standpoint, it's way more efficient and less expensive for people to have a 10-minute phone call rather than a 10-minute court appearance that requires basically 2 hours of commitment of your time to come here and sit around and wait and talk and then go back and go through security on both ends and whatnot. But so I think there's going to be more of a trend, towards. I'm at work right now, and I'm sitting here in this gigantic office, and there's nobody else here. Nobody. My assistant's not here. My law clerk's not here. They're all working at home. My court reporter, I had all these hearings today. She's sitting at her home. My courtroom deputy clerk, she's sitting in her home. I think there's going to be more and more of that. That's a damn shame too. And I mean, it's great for a lot of people. It's on an individual basis, it's great for a lot of people. It gives people a lot more contact with their family. I mean, a place like Chicago, you're saving 2 hours every day. You're saving that 2 hour commute. That is great in a lot of ways, but in terms of, what does this mean for the system of justice that we're now just doing stuff on the phone? And I don't think it's good. Sorry.
That's okay. We can end on that note.
All right. Well, hopefully you'll get 5 minutes worth out of this anyway. So.
I think I got a few more than that. But Judge Kennelly, thanks so much for taking the time. Very fascinating, insightful, and really appreciate you.
Well, thanks for the opportunity. It was fun.